Imagine being a golf legend, a household name synonymous with integrity and excellence, only to have your reputation tarnished by false accusations. That's exactly what happened to Jack Nicklaus, who just won a staggering $50 million in a defamation lawsuit against Nicklaus Companies. But here's where it gets controversial. Was this a case of a company protecting its interests, or a deliberate attempt to smear a legend's name? Let's dive in. On Monday, a Florida jury awarded Jack Nicklaus $50 million after finding Nicklaus Companies guilty of defamation. The case centered around claims made in 2021 that Nicklaus had met with LIV Golf, a Saudi-backed competitor to the PGA Tour, to discuss a $750 million deal to become their brand ambassador. These claims were leaked to the media, sparking widespread speculation and damage to Nicklaus's reputation. Nicklaus and his legal team, led by attorney Eugene Stearns, argued that these allegations were entirely false. Stearns told ESPN, "In defamation cases, proving harm to someone like Jack's reputation is challenging, given his long-standing positive image. But the real issue was the false narrative spread 3.5 years ago, suggesting Jack was abandoning the PGA Tour for Saudi Golf. We're relieved that Jack's name has been cleared." According to Nicklaus, his meeting with Saudi Golf was solely about designing a new golf course. When LIV involvement was broached, he declined. The jury agreed, ruling that Nicklaus Companies had damaged his reputation by spreading false information, subjecting him to ridicule, hatred, mistrust, and contempt, as reported by the Palm Beach Post. And this is the part most people miss. This isn't the first legal battle between Nicklaus and Nicklaus Companies. The golf icon parted ways with the company in 2017 after selling the rights to his golf courses, club brand, and Golden Bear clothing line. He fully stepped down from the board in 2022. A 5-year non-compete clause was in place, but Nicklaus Companies later accused him of diverting business for personal gain. In 2024, a Florida arbiter ruled that Nicklaus was no longer bound by the non-compete, and this April, a judge allowed him to use his name, image, and likeness freely. This case raises thought-provoking questions. How far should companies go to protect their interests? And at what point does it become a personal attack? Here's a bold interpretation. Could this be a cautionary tale about the dangers of corporate greed overshadowing individual legacy? We'd love to hear your thoughts in the comments. Is Nicklaus Companies justified in their actions, or did they cross a line? Let the debate begin!